All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for our Strategic Advocacy Across Courts, Agencies, and the Legislature CLE series, and this is segment number 2, Purpose and Utility of Test Cases. Before I introduce and pass it over to our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so we will be posting it on YouTube probably this afternoon. If you registered, you're going to receive a copy of the recording, a link to the materials, and the CLE code via email from Zoom within about 24 hours. So if for whatever reason you missed that, be on the lookout for the YouTube description because I've been adding all that information in there. If you missed registration and you want to share this CLE series with others, feel free to share those links or forward that email. That way they're going to be able to watch the first segment and they're going to be able to register for the upcoming segments as well. So this training was approved for a lot of CLE credits. So bear with me. We have one general CLE credit. We have one Appellate practice certification credit. We have one state and federal government and admit practice certification credit. We have 0.5 professionalism credit, and we have 0.5 ethics credit. I feel like Oprah right now. Like everybody gets CLE credits.
Yes.
So big credit to Viletta because when we were discussing this series, we were able to strategize around this and get all these CLE credits. And Viletta just mentioned something really interesting that I really didn't think about. If you go through all 4 segments when we finish up the series, you're going to end up with 2 professionalism credits and 2 ethics credits. So that's a big takeaway from this series. So I will announce the CLE code for this segment towards the end. It will also be included in the slides. I will drop it in the chat. It will go out via Zoom, via email, and it will also be included in the YouTube description as well. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or captions, please reach out. You can reach out through the chat or email me. And really important, this training is being co-hosted by the Public Interest Law section, PILS, and the Admin Law section, ALS. So I'm calling us PALS now because that's the acronym that I came up with for both of our sections when we combine them. So I'm going to drop a lot of links in the chat. All these links are going to be included in the emails that go out from Zoom. I will also include them in the YouTube description. But these links are going to be links to our websites, both for Public Interest Law section and Admin Law section, all of our social media accounts. So please subscribe, follow, and follow us on social media, and bookmark those websites just in case you need to access. Look at our membership benefits. There's also a lot of committees and work groups that you can look to join, and a lot of benefits from joining these sections. So final piece of housekeeping announcements, questions and answers. If you have questions, we are going to ask you to please hold them towards the end because we have a lot of content to go through. If for whatever reason you have questions that are not addressed, feel free to email me and I'll make sure that I can get those questions to our speakers in case we don't have time today to answer all your questions. So without further ado, I want to go ahead and quickly introduce our speakers. I included the full bio in the materials, which I will drop a link to after I'm done with the housekeeping announcements. First up, we have Judge Anthony Miller. Judge Miller has served as a circuit judge in Florida's Second Judicial Circuit since 2020 and is the administrative judge for the Family Law Division, presiding over a wide range of family law matters. He previously served in the Dependency Division and is a strong advocate for trauma-informed judicial practices, serving as the circuit's trauma-responsive judge representative. Before joining the bench, he served as a county judge and held senior legal roles with Florida state agencies. Our other speaker is Viletta Coombs. Viletta is a Florida bar attorney with more than 20 years of experience in administrative, legislative, and litigation advocacy. She has dedicated much of her career to public interest work with Florida Legal Services and multiple Florida state agencies, focusing on serving vulnerable children and families. Viletta is also an experienced trainer, presenter, and leadership development professional. So without further ado, it is my absolute pleasure to pass it over to Viletta and Judge Miller. The floor is yours.
Thank you so much for joining us today for the strategic advocacy across courts, agencies, and the legislature. As presented by myself, Viletta Coombs, and Judge Anthony Miller. And special thank you to the Florida Legal Services Statewide Training Initiative and the Administrative Law Section and the Public Interest Law Section of the Florida Bar for sponsoring this CLE series. Before we begin, I'd like to provide a disclaimer. The content of this CLE, as well as the views and opinions expressed by the CLE presenters, do not reflect the views of current nor former employers, including but not limited to Florida State University, Florida courts, Florida agencies, and the Florida Bar. The presenter's views are their own and not legal advice. The presentation of this information does not form an attorney-client relationship, and this information is for educational purposes only. At this time, we'll begin segment 2, the purpose and utility of test cases.
Yeah, before we get started, I want to thank my co-presenter for inviting me to be a part of this program. And I thank everyone participating for joining us today. It's always encouraging to see members of the Florida Bar take time out of their busy schedules to participate in conversations like this, which I think are very important. Now, to kick things off, let's do a quick thought experiment. We have a lot of lawyers, of course, on this webinar, and every lawyer in this webinar, probably has handled what seemed like a routine case, a single client, a single dispute, a narrow legal issue. But sometimes those cases turn out to be something much bigger, and I'm sure some of you all can relate to that. A case that clarifies the law, resolves conflicting decisions, or changes how courts handle an issue statewide. Those are what we call test cases. And many of them begin not with grand strategy, but with an everyday legal problem that lands on a lawyer's desk. Whether that lawyer is in private practice, government service, public interest work, or serving as in-house counsel. Think about when lawyers hear the phrase test cases, talking about trauma. They mentioned that I work with trauma. For some of us, law school, harking back to some of those experiences, maybe some shared trauma. The first thing that often comes to mind are those landmark cases that we studied in law school. Remember Marbury v. Madison? Many of you can recite what it stands for, which established judicial review and confirmed the authority of courts to invalidate unconstitutional statutes. McCullough v. Maryland, as indicated on the slide, confirmed federal supremacy and recognized implied powers under the Constitution. And then Miranda v. Arizona, a 1966 case, required that suspects be advised of their constitutional rights before custodial interrogation. These are the classic examples we associate with test cases. But the important point for today's discussion is that the test cases do not only occur in the United States Supreme Court. They arise regularly in trial courts, administrative proceedings, and district courts of appeals. In fact, many attorneys may find themselves involved in a test case without even realizing it. And we'll discuss that more as we go through the presentation. That is especially relevant for lawyers like yourselves engaged in public interest work, administrative law, many other areas of the Florida Bar. Let's discuss the purpose of a test case next. Test cases are designed to challenge, interpret, and clarify specific law. At its core, the issue might involve a statute, a constitutional provision, an administrative rule, or conflict in appellate decisions. Remember, test cases are designed to challenge, interpret, or clarify a specific law, regulation, or constitutional principle to set a legal precedent. What distinguishes test cases from ordinary cases that the outcome extends beyond the individual litigant. The case becomes a vehicle for establishing precedent that will guide future cases. And you may ask why test cases matter in public interest work. Public interest litigation often begins, as we discussed, with a single client and a specific legal problem. But sometimes a lawyer recognizes that the issue is not unique to their client. Instead, it reflects a systematic issue affecting many similarly situated individuals. And when that realization occurs, the case may evolve from a private dispute into an effort to clarify the law for everyone affected by that issue, which speaks to that broader impact. Now let's look at the strategic value of test cases or the practical utility of these cases. From a practical standpoint, test cases often involve 3 steps. or processes. Or four slide. First, you identify the issue. Is a statute unclear? Are the agencies applying it inconsistently or beyond the delegated authority? Are courts interpreting the law, differently among the different circuits? Secondly, develop a legal strategy. That strategy may involve litigation, administrative advocacy, legislative advocacy, or some combination. And we'll discuss that a little further too. Thirdly, attorneys sometimes identify a case with the right factual posture to present the issue very clearly. That may involve what we consider an ideal party, strong facts, a clear legal question, and a procedural posture that allows appellate review. So from a judicial perspective, I can say that courts are often more willing to address broader legal questions when the issue is presented cleanly. Talking about that larger impact at the bottom of this presentation, outcome impacts all people, entities with that issue. So clear facts and a well-developed record make it easier for courts to address issues that affect many people. Next is discuss, and we've kind of hit on this as far as the legal pathway to relief. The legal strategy is contingent upon the legal pathway to relief. For instance, the issue or claim may be pursued through the court, a grievance process, a regulatory board, commission, or licensing agency. It may be through an informal process. I've worked inside of several state agencies. You name a state agency I've worked for: Department of Insurance, which is now Department of Financial Services, Department of Corrections, Department of Management Services, Department of the Lottery, and so on and so forth. I ended before I became a judge, I was general counsel for the Agency for State Technology. And a lot of times I experienced firsthand that a lot of the issues or problems were resolved through an informal process, simply meeting with the leadership team. Stakeholders would come and discuss different issues. So but going back to these legal pathways, you have congressional hearings, state or federal legislation, a court of public opinion or a combination thereof. With the ubiquitous use of social media, the court of public opinion is becoming a increased use by many individuals. Sometimes that's effective, sometimes it's not effective, but it is one of the things that strategically individuals do look at. We're now going to kind of bridge over to an actual example. This is a hearing on issues related to the safety of Accutane. The issue presented here is that acne medication that did not include a warning of depression and suicide as possible side effects. So a very critical issue affecting individuals. The result, the warning labels include more possible side effects regardless of the likelihood of the side effects. So you see that broader impact, the outcome impacts all people taking all the over-the-counter prescription medication. So that's some very, very important to note. Now we'll kind of move on to, another aspect of this discussion is it may be also helpful to recognize that some legal issues fall within the oversight of administrative agencies, regulatory bodies, or legislative entities. And we've come in on some aspects of that. In practice, matters sometimes arise when where the issue is addressed not only through litigation in the courts, but also through proceedings before the relevant agency oversight bodies. As a result, legal issues may be presented through various points of entry, depending on the applicable statutory regulatory framework. In some circumstances, different stakeholders, including advocacy groups, professional organizations, or affected parties, may also become involved in addressing the issue. The key point from all this is that the courts represent one of several potential pathways through which legal questions may be raised and resolved. But litigation, as you all know, can be very expensive, very costly. And so clients have to weigh these different pathways when they consider how to move forward. We now will address intentional versus unintentional test cases. Intentional cases are those strategy. There's a strategy to bring the test case, identify the issue, develop the legal strategy, and pick the perfect client. I don't know if there's such thing as a perfect client, but ideal client. These are cases deliberately designed to challenge existing law. A well-known example is the Brown versus Board of Education, intentionally litigated to overcome the separate but equal doctrine and racial segregation in public schools. A lot of us are very aware of these string of cases. In that situation, the legal strategy was carefully developed to present the constitutional issue to the Supreme Court to a successful end. Now, as far as unintentional test cases, which we'll explore next, unintentional test cases, case begins, as we discussed, as a routine dispute involving one client, but as the case progresses, it becomes clear that the legal issue affects many people. And one of the most famous examples is Gideon v. Wainwright, a 1963 case. And that case held that the Sixth Amendment requires states to provide counsel to criminal defendants who cannot afford an attorney. Clarence Gideon simply wanted a lawyer in his criminal case. I don't think he had this grand strategy that he was trying to get an attorney for all the other individuals throughout the various states. He appealed his conviction to the United States Supreme Court, and here's a fascinating fact. Gideon wrote his petition to the Supreme Court by hand from his prison cell. That handwritten petition ultimately led to one of the most important criminal procedure decisions in America's history and helped expand public defender systems across the country. Think of the impact of this one decision. It's a powerful reminder that sometimes a single case can reshape the law in ways no one initially anticipated. Now, before we transition to the case study, my colleague, Ms. Coombs, will discuss, let me make a few summary observations. Again, sometimes test cases arise from complex constitutional questions. Sometimes they arise from complicated regulatory frameworks. And sometimes, as you're about to see, they arise from a fifth grade classroom, well-informed student in a 5-foot-ball python named Patty, but I won't steal Ms. Coombs' thunder. One thing I've learned from the bench is that real-life fact patterns are often far more creative than anything we can invent in law school hypotheticals, but even unusual facts can raise serious legal issues with broader implications. So now we'll turn to the case study that Viletta will highlight.
Thank you so much, Judge Miller. The following case study is based on factual events between 2010 and 2011. Factual events pertain to the unemployment compensation appeal with the Unemployment Appeals Commission, which is now known as the Reemployment Assistance Appeals Commission, and everything thereafter. So the appellate process is our factual inspiration. Now, for the purposes of the case study, this incident takes place in Marshland, a fictitious state that follows Florida law and mirrors Florida's system of government, executive, legislative, and judicial. Strategic advocacy case study. We're at Marshland Academy. Our defendant, her name is Mandy Magpie. She was born November 11, 2000. She's in the 5th grade at Marshland Academy, and the date of the offense is 11/11/2010. So Patty is about 10 years old right now. And the charge is called disruption under Florida Statute 877.13. And our referral source is a probable cause affidavit. Here are the facts to support the charges, as reported by Deputy Ozzie Irwin with the Marshland Police Department. According to Mr. Swamps, the 5th grade homeroom teacher, the incident occurred when students were transitioning from the classroom to the lunchroom. As students lined up at the classroom door, Mandy Magpie, Mandy, jumped out of the lunch line and headed towards the classroom aquarium. Mr. Swamps gave Mandy several warnings to return to the lunch line. Upon review of the classroom video recording, Mandy can be seen removing the class pet, Patty the Python, Patty, from the aquarium and placing the 5-foot, 6-pound ball python on the carpet floor. Almost immediately, students can be seen running frantically throughout the classroom. Patty can be seen slithering aimlessly around the classroom and eventually into the main hallway. Upon review of the main hallway video recording, students can be seen leaving their classrooms as the lunch bell rang. And when students encountered Patty in the main hallway, it resulted in a stampede in which numerous students were injured and transported to the hospital. Patty slithered aimlessly in the main hallway until she was retrieved by Marshland Animal Control. When I arrived, as told by Deputy Ozzie Irwin, when I arrived and questioned Mandy, she confessed to removing Patty from the classroom aquarium without permission and supervision from Mr. Swamps. Patty was removed from the academy. It may not be possible to relocate Patty because ball python, they have no natural predators in marshland. Therefore, there's a possibility that Patty may be euthanized. And this is the intake interview with Mandy Magpie and her parents, as told by Mandy. I knew lunchtime was my chance to rescue and free Patty from the classroom aquarium. You see, I recently read an article in the Mighty March blog about protecting animals in their natural habitat. I knew that Patty came to Marshland Academy as an egg and grew up here in captivity. I thought she may want to be free to find other ball pythons and live with them. I did not mean to hurt Patty or anyone at the academy. I just wanted to be a good student and protect the environment. I'm sorry that many students were hurt in the stampede. I received punishment from my parents, no social media, and cancellation of my junior memberships to activist groups. Mr. Swamps, a 1,000-word essay on actions and consequences. And the Academy, temporary suspension and cancellation of the Academy Nature Club, which I started. I enjoy splashing in the mud, reading, working with animals, and preserving the environment. And when I grow up, I want to be a zoologist, a veterinarian, a park ranger, or a pop star. Because after all, she's 11. So now we're going to talk about Mr. Swamp's unemployment appeal. Following the incident with Mandy Magpie, Patty the Python, and student injuries resulting from the stampede of students in the school hallway, Mr. Swamps was suspended from his teaching position, and shortly thereafter, he was terminated from his teaching position. And by the way, Patty the Python was the principal's pet. Mr. Swamps had no control over Patty being assigned to Mr. Swamps' classroom. Mr. Swamps timely filed a claim for reemployment assistance benefits, formerly known as unemployment compensation benefits. Mr. Swamps' claim was denied. He timely filed an appeal. At his appeal hearing, the appeals referee agreed with the original determination, denial of benefits. Mr. Swamps timely filed an appeal with the Reemployment Assistance Appeals Commission, RAC. Upon review of the record, RAC issued a final order upholding the appeal referee's determination, denial of benefits. Mr. Swamps, a resident of Bog County, Marshland, timely filed an appeal of the RAC's final order with the Marshland Second District Court of Appeal, the DCA. The second DCA transferred Mr. Swamp's appeal to the Marshland First DCA. So let's talk about clarifying and interpreting and changing existing law. In this scenario, you represent Mr. Swamps in his appeal to the second DCA. You don't understand why the second DCA transferred the appeal to the first DCA. So you review the statute, which at the time is a 2010 statute. It's section 443.1514E, which states judicial review. Orders of the commission entered under paragraph C are subject to review only by notice of appeal in the District Court of Appeal in the appellate district in which the issues involved were decided by an appeals referee. This is the most important part of the statute. The appellate district in which the issues involved were decided by an appeals referee. you're starting to realize this issue might be a little bit bigger than Mr. Swamp's, because as you review the statute, the case law, public records, you begin to understand that there are conflicting DCA opinions regarding the proper venue for RAC appeals. The venue for RAC appeals impacts Mr. Swamp's as well as all unemployment claimants. You see, if the issue is bigger than Mr. Swamp's and the outcome impacts more people than Mr. Swamp's, this is what you would call a test case, because this case will create precedent that will impact all RAC appeals. And so this is what we would call a systemic issue, and the outcome has the potential to result in systemic change. At this time, we're going to launch an ethics poll, and I'll let Jorge get that ready. This is your poll, and I'll read it to you. It's available on the screen, and all of the language is available in the PowerPoint. The poll itself had character limitations, so answer 1, 2, 3, 4 based on the PowerPoint. Here's your poll. The Marshland Department of Commerce, the state agency that administers the federal unemployment insurance program at the state level, makes an offer to settle the case. What is your ethical duty? 1, ignore the offer. 2, inform Mr. Swamps about the offer and proceed as directed by Mr. Swamps. 3, inform Mr. Swamps about the offer. Advise Mr. Swamps about the legal options related to accepting or rejecting the offer, including the potential consequences of each course of action. Explain how the resolution of the case may affect him and may have broader implications for other similarly situated individuals with RAC appeals. Thereafter, proceed in accordance with Mr. Swamp's informed decision. 4, inform Mr. Swamps about the offer and advise him to decline the offer and continue the case, because the outcome of the case will impact other similarly situated people with RAC appeals. At this time, if you haven't already, please complete the poll.
So based on participation, we are about 50%. So let's give everybody about a minute to be able to answer. Right. So we have 50%, 58%. I'm going to shut it down and the poll in about 5, 4, 3, 2, 1. And I'm ending the poll and I'm sharing the results. Everybody should see them on their screen. It seems like answer number 3 was the most popular by far, with 93% of attendees selecting number 3. We had 3 people select number 2 and 1 person select number 1, ignore the offer, and nobody selected number 4. So number 3 seems to be the most popular by far. Back to you, Viletta.
Thank you. And I would like to ask Judge Miller to explain to us why number 3 is the correct answer.
Yeah. Number 3 is the correct answer because first of all, it lines up with the professional rules of conduct that lawyers are bound by. As attorneys, when your client comes to you and they want to do certain things, I've been in-house counsel, and a lot of times I disagree personally with what they want to do, but my role a lot of times is the business entity. For example, when I was within a lot of agencies or program area, my goal is to advise them of all their legal options, not to make the decision for them. So clearly the answer, just don't tell them about it or whatever, that's a non-starter. But it's important that we understand our role as attorneys, and 93% of you all get it. But if I can encourage the other percent of you all who answered differently, I encourage you just to understand strongly your role as an attorney. You're not the decision maker. It's important that you understand, advise your client. A lot of times, as long as they're not making an illegal decision, it's their decision to make, even though you may disagree with it.
Understood. And at this time, I'm going to ask Judge Miller to continue with his presentation.
All right, we will pick up on conflicting District Court of Appeal decisions. This touches on some of the things that Viletta has as part of her presentation. And that involves something Florida lawyers encounter fairly often: conflicting decisions among the District Court of Appeals. Florida now has 6 District Court of Appeals, each responsible for reviewing causes arising from trial courts within its geographic jurisdiction. And a lot of times, the trial court gets it wrong. I have been appealed successfully. Thankfully, that has not been a pattern. I try to make good decisions consistent with the law, but sometimes trial judges and trial courts in one area are handling different matters in a different way because of conflicting decisions within the circuits. Most of the time, those courts interpret statutes and legal principles consistently, but occasionally different DCAs reach different conclusions about the same legal question. When that happens, the law may operate differently depending on where someone lives in the state, which is not ideal. From a judicial perspective, that raises concerns about fairness, predictability, and the uniform administration of justice. If you're advising clients, especially business clients, you understand the importance from a business standpoint. They want their business concepts to be consistent in the Second Circuit versus down in South Florida. Ideally, the same rule of law should apply throughout Florida. And so moving toward resolving those conflicts to the next slide, there's where the Florida Supreme Court plays an important role. In the Florida Rule of Appellate Procedure 9.030, the Supreme Court has discretionary jurisdiction to review decisions that expressly and directly conflict with decisions of other district courts of appeals. This allows the Supreme Court to step in and resolve conflicts so that a single rule applies statewide. Now, a lot of times it operates more in theory than in practice. I'm sure some of you all may have participated in litigation where you were disappointed that the Supreme Court may not have exercised their discretionary review, but it is discretionary, so they may not do so. Now, as we kind of move through the next group of slides, these next group of slides, they really kind of highlight how conflicting district court decisions can form the basis for seeking review by a state Supreme Court. We won't walk through all the nitty-gritty details of that, but instead I would encourage you to look at those closely. But as we kind of go through these slides, I'll highlight certain aspects of it that are very important. For example, here you filed the appellate's brief with the Martian Supreme Court. In this excerpt from the appellate's brief, the second DCA's decision to transfer RAC appeals to the first DCA conflicts with decisions of the third and fifth DCAs, which highlights the importance that from a judicial perspective is important for you as the litigator to explain to the court, why does this matter? What is so important about this? So it's important the way you draft these briefs, the way that you put these ideas before the courts. Don't assume that the court is going to really capture the essence of what you are trying to say. You have to communicate what those are. Moving to the next slide. Here, the brief indicates that the second DCA's decision transferring the appeal to the first DCA and the Lynch v. Unemployment Appeals Commission, on which is based, directly expressly conflict with the third court's ruling. So directly points to the problem. What is the problem? And then it goes on, it says the court explains the different rulings and the impacts of them. So in a nutshell, what they show is how an appellate identify conflict in interpretations of the same statute across different districts, framing that conflict as a basis for discretionary review, so a higher court can establish a uniform rule of law statewide. So we'll move to the next kind of group of slides and go to the next one as well. One of the things that I want to highlight at this point is that practical advice for attorneys. For attorneys practicing in Florida, there's important takeaway as you kind of review and consider these slides. When you encounter conflicting appellate decisions, the instinct may be to simply argue the case that favors your client. That is certainly appropriate, but sometimes lawyers should take an additional step. If the issue truly involves conflicting decisions among districts, you may consider requesting that the court certify conflicts to the Florida Supreme Court so that the Florida Supreme Court can resolve the issue. And that allows you to really understand your case, highlights the importance of understanding your case. And a lot of times as lawyers, we can myopically just look at our case and we're focusing on winning that case and winning on the merits, which is very important. But also, too, you got to look at those broader indicators that we talked about. There's also another important professional dimension to this. When attorneys thoughtfully identify conflicts in the law and clearly present those issues to the court, they are not only advocating for their client, they are also contributing to the clarification and development of the law. In doing so, lawyers reinforce core professional obligations reflecting the rules of professional conduct, including competence, candor toward the tribunal, and assisting courts in reaching well-reasoned decisions, which is what we want at the end of the day. We want consistent, well-reasoned decisions. From my judicial perspective, when attorneys raise these issues responsibly and thoughtfully, it strengthens the administration of justice and helps ensure that the law is applied consistently across the state. To give you one example of a recent, even family law case, I was recently appealed successfully on some issues in a family law case, and I remember, and that's the importance of the appellate courts. I remember when I went through what they call New Judges College when you're a judge, a county judge, or circuit judge. One of my mentors, she kept saying, "Don't be afraid to make new case law." And as judges, we used to be petrified of being appealed successfully a lot of times. But now I've grown to understand that the role of a trial court is to make the decisions based on the facts as you understand it and as you understand the law. And the appellate courts are there and they have the oversight for a very important reason, because the decision that I made and the DCA ruled on it and overruled me, now that area is settled among our circuit, and where there's no dispute among the other circuits, settled throughout the state of Florida. So I was very, encouraged to look at it from that standpoint, that even when we make mistakes at the trial court level, understanding the importance of clarity is an opportunity for the appellate courts to really make plain what the law is and that to apply in a consistent way.
Thank you, Judge Miller. I just want to circle back to a point that you were making, and I'll go through this slide right here where it says this is a part of the appellate brief that you, as the members of the trial team for Mr. Swamps, have filed this brief with the Marshland Supreme Court. And you're saying to the Marshland Supreme Court, the Marshland Supreme Court should accept jurisdiction to review the decision of this case and resolve these conflicts. That's what we've been talking about this entire time, are the conflicts they need a resolution. The current state of the law requires that the unemployment claimants in the second DCA file their appeal in Tallahassee, while those in the other districts may file theirs in their home appellate district. And the state of affairs is inconsistent with and prejudicial to the fair and orderly administration of justice, because a single rule should apply to all Marshlandians. If there were ever a theme with regard to conflicting DCA opinions or conflicting law, is that the single rule or that single process should be consistent and apply to all. You shouldn't have the same set of facts come before the court and just have different outcomes. That's not an orderly administration of justice. And I think that captures the essence of what Judge Miller has been talking about with specificity. Unless you have anything further to add, Judge Miller, I will move us into our Q&A.
Okay, I was just going to wrap up some of my observations
Mhm.
before we do the Q&A. And
Yes, sir.
from my perspective, test cases, as we indicated, often begin with a single client, a single dispute, but sometimes that dispute raises questions that affect people across an entire state or even the entire nation.
Mhm.
Recognizing when a case has that potential and presenting the issue clearly to the court is one of the ways lawyers help ensure that the law remains fair, consistent, and responsive to the needs of the public. And that wraps up, as you described, the importance of the administration of justice um, and clarity.
Thank you so much. So at this time, we have really done a good job to stay on pace. And we're actually early. So at this time, we can do our Q&A. And I can tell you, as Jorge is setting up to do our Q&A, that you're going to hear more about Mr. Swamp's situation in segment 3 and 4. And also we'll hear more about our Mandy Magpie.
We do have a question in the Q&A. This one came in about like 15 minutes ago or so, actually 10 minutes ago. And the question is, what if the new DCA has better law than the DCA the case was transferred from?
Well, now you're talking about doing a bit of forum shopping. And this is something that I had to deal with when I clerked for the trial courts in Kansas City, and I also clerked for the Missouri Court of Appeals Western District. And there were instances in which one district decided the same facts a different way than another district. But the way that you could file, depending on the outcome you wanted, you could probably file at either district. That's a problem because now we've got forum shopping and we still don't have the uniformity with respect to the application of the law. Ideally, if you find a law in a DCA that you think is more favorable, then argue that this should be the standard. Okay. But I wouldn't ignore it. And I wouldn't necessarily just argue it's the better case. It really does serve everyone better if we were to have consistency amongst our DCAs. Judge Miller?
I like your comments because it shows that as attorneys who are sworn to certain rules of professional conduct, that we have to comport ourselves with candor, as we talked about earlier. And a lot of times you have to explain to the court or even submit to the court that, hey, this is the law, even though there's what I think is more persuasive law in another circuit. You have to be candid with the court that, hey, this is the law as it indicate, as noted in our circuit, unless there's some way to distinguish your facts from what the case stands for. But if there's an opportunity to distinguish the case, however, if it's on point, it's on point. And and you just have to be honest with the court. I tell you, one of the things that attorneys lose their integrity with the court is when they cite a case and kind of like cherry pick what they want, but then they don't also acknowledge other cases too that may say something else. I think full candor with the court is vital, and you lose your integrity as a attorney. And not saying that this question is suggesting that, but I felt the need to kind of expand it a little further as to what's important from my professional conduct standpoint.
Right. Another question just came in, so I'm going to read it out loud. Doesn't your legal obligation to your client matter more than trying to change the system? If there's sufficient legal grounds to file a case in the DCA with better law, why would filing in the other DCA not be ignoring the best interest of your client?
Yeah. I cannot address that one Violetta, I think all this has to be done in consultation with your client. Your client may not be the client who wants to take on that broader issue. So if that's the case, you have to definitely defer to your client because you're not the one driving, but you owe it to your client to explain the different ramifications, and the client may be willing to expand the litigation one way or another. So we're not asking or encouraging you in any way to short shorten the analysis with the consultation with your client. So I just want to address that aspect, but Vlad, I'll let you address the other aspect. We're getting some feedback. I don't know if somebody's talking.
Okay. I just want to say that I would be careful, um, because I think it's best to be thorough. If you're submitting, your brief to the court, which you have to do in these instances, I would put in all the law, and then the court can decide how they want to decide, because they have a responsibility of their own too when they see amongst themselves when they have conflicting opinions. That doesn't necessarily fall on your client. But if this is something that I want to say is brewing, it's eventually going to come out. But it doesn't always have to come out in the context of the DCAs, because as you'll see in segment 3, there are multiple ways that these particular issues start to resolve. Um, but I'm not saying your client has to be the flagship test case for something, but I would always be thorough in anything that I would file with a court. I wouldn't just present one side.
Yeah.
It's going to hurt you, I think.
And I think too, one of the inputs or consultations too, Violet, I was thinking when you're talking to a client, if it has the potential to become something larger, I do think there's a duty to tell the client that, because maybe the client doesn't want media exposure or other exposure. That's why I think that conversation has, to the extent that you're able to predict or understand that this might be a broader issue, I think we would owe it to the client to convey that, unless it is just one of those things that you couldn't foresee that it was going to become a national issue. Let's just say you were an attorney. I guess well, he was arguing that he didn't have a public defender, but let's just say that you were an attorney representing Gideon B. Wainwright, not his criminal attorney, but just represent him, from the standpoint of the appeal. And maybe you wouldn't think, man, this is going to end up in you being the poster child for what becomes a national movement. Uh, so sometimes you can't anticipate it, but to the extent that you are able to, I think we can, owe it to our client to convey as much information as we have at the time.
I have another question that came in, and I'm going to read it out loud. So, how should you sort potential conflict issues if there's a prospective client with a similar issue?
I think that's a really good question. I think that you're not necessarily going to disclose information about your clients to each other. That's for one. But if you think that there's a conflict, you may need to discuss the fact that you think there's a conflict with your current client. And if you decide that you want to proceed with both, you're going to have to figure out how to do that. I mean, there's always a possibility of a waiver, but that doesn't mean that it's a good idea. And it's kind of vague because I'm not sure specifically what that particular conflict is, to provide a more detailed response. Judge Miller?
I don't have anything to add. I thought you addressed it to the extent that we're able to understand the parameters of the question.
All right, I don't see any other. Oh, here we another one just came. Oh no, this is the same one. Okay, so I just didn't mark it as done. Okay, and I don't see any other questions in the Q&A in the chat, so I'm gonna take this opportunity just in case other questions come in. We still have about 9 more minutes left, but I know it seems like we might be able to wrap up early. I'm dropping the link to the materials again in case you were not able to see it. I'm going to read out the CLE code for everybody's benefit. I will also drop it in the chat as well. The CLE code is 2600948N. So I'm dropping it right now in the chat. I will also send it via email. It will also go out. It will also be in the YouTube description. If you copy it, be careful not to copy the spacing because then when you paste it into the bar's website, it might not recognize it. I will also drop the links for the next sessions. We have another one happening next week, so make sure to register for both. Once you register, you should get a confirmation email from Zoom. If you don't get it, if you know you registered and you did not get a confirmation email, let me know because it could be a Zoom issue sending out the email. It could be a typo in the
Mhm.
email. So if for whatever reason it's not sent out, we'll figure out a way for you to get the link to be able to join the next webinar. These are being recorded as well, so if for whatever reason you missed it, you're going to be able to find it on YouTube afterwards, and be able to apply for credit afterwards. So we see on our screen, we see the information for the next two sessions. We have one next week. We're skipping 1 week, and we are wrapping it up on March 31st. So. Let's take another look at the chat and the Q&A to see if there are any other questions, but I don't see any questions. So any final statements by Letta and Judge Anthony Miller before we wrap up?
Oh, I just want to say that this issue that we're discussing about Mr. Swamps, we really do break it down further in segments 3 and 4. It's actually very complex because there are multiple things happening with the case, and I think that's something we often face is that we have a client that has numerous issues, and we have that case actually may have various aspects to it, and we're trying to figure out the scope of what we can or can't do given our position, situation, or resources. That said, I want to give a special thank you to Judge Miller for co-presenting segment 2 with me today. I sincerely appreciate it. And also, again, to the administrative law section and the public interest law section of the Florida Bar and the Florida Legal Services Statewide Training Initiative. Thank you for sponsoring this CLE series.
Yeah, similarly, Viletta and Jorge, I want to thank you, Viletta, as co-presenter, and Jorge, just a lot of the behind the scenes and connection points throughout the presentation, and for everyone joining us today. Just an incredible participation. Hopefully, you all got something out of it as we discuss many important developments in the law, begin with what appears to be an ordinary case. And when attorneys approach those issues thoughtfully and with high responsibility, they help courts clarify the law and promote the fair administration of justice. As frustrated as lawyers may get with judges, we do want to get it right. We do try to get it right. Sometimes we don't, but it's an opportunity for greater advocacy, greater clarity. And so we thank you all for your time and participation. I think this has been a very worthwhile presentation, and I recognize all the partners involved as well.
Thank you.
Thank you, everybody. Have a great rest of your day.